Srinivasan?
Yes, sir.
Yes.
Am I able to start?
We can start, sir. Srinivasan, sir.
Respected Principal, sir, Dr. N. Anbuchalian, sir, our Head of the Department, Dr. P. Elumalai, sir, our IAC Coordinator, Dr. P. Gangaman, ma'am, Entrepreneurship Cell Coordinator, Ms. Kartiha, madam, all Head of the Department, professors, faculty members, and students. It is my pleasure to welcome you all to this workshop on intellectual property rights. I'm happy to introduce today's guest, Dr. Balaji Ganesh. He completed his PhD degree
Yes, Srinivasan.
yeah.
Mute it.
A very good morning to all of you. On behalf of our management, R.M.D Group of Institutions Management, wholehearted welcome to our chief guest, Dr. A. Balaji Ganesh, Dean Research, Vellamal Engineering College. He is the qualified patent agent and he is also the founder and the director of IPR LLP. It is situated in Kolattur, our nearby area, Chennai. We are very happy that Mr. Balaji Ganesh is here, and I am very happy to welcome him for this wonderful session on IPR and IP management for startup. This is being organized by two separate entities here. One is our Anna University's Entrepreneurship Development Cell, EDI, and another one is our Institute Innovation Council. So on behalf of our IAC and EDI, once again, I welcome Dr. Balaji Ganesh. Now over to Dr. Balaji Ganesh.
Thank you very much, sir. Thank you very much. And before anything, I would like to thank for the organizer, principal sir, and IAC of R.M.D College and EDI of R.M.D for giving me the opportunity. This particular the topic, it's a need of our, and having understanding about intellectual property equally important to faculty as well as the student. Yeah, never mind that someone has muted my mic. Okay, so never mind that this is the topic that we are going to have the discussion in the next 1.5 hours. But you are most welcome to interrupt me at any point of time. As well, if you have any the doubts or any point that needs to be addressed before the discussion that today or intermediately any point of time, any of your queries need to be answered, you are most welcome to interrupt me. As per the suggestion from the organizer, we are going to have the discussion on why we need to promote an IPR, what could be the different management strategies an individual, faculty, student, and the startup company they have to look at in order to get the maximum profit out from their an IP, intellectual property they have created. Also, that we are going to talk about the patent filing procedure. As per the Indian Patent Office, any individual, the natural person, he or she, himself, herself, can file their own patent. Only then aspect is they need to understand what could be the procedures are being followed by the patent office. If you do know about those procedures, you yourself can file your patent. So we are going to have the discussion on, as an individual, how you could file your own patent, the patent filing procedures. Pertinent to the topic, it has been assigned to me for today. We are also going to talk about the opportunities for a startup. What kind of the promotion, the policies, the government, they have enumerated, especially for the startup towards the IPR, the registration. We are going to have the discussion. I would like to ask you in a very humble manner, what would you do when you purchase a vehicle, a two-wheeler or the four-wheeler? When you purchase a vehicle, the very first then aspect, every one of us that we would do, it is a registration of the vehicle by visiting the respective the registration office. Similarly, if a land or the home, a real estate, when it has been procured, the very important aspect that we would tend to perform ourselves, the registration of the immovable asset in our name. The reason why we are registering, it is very obvious that we are creating a record to show the particular, the movable or immovable asset, it is mine. It is an evidence that we are creating. In any court of law, if any other person, they are claiming they are the owner for the movable or immovable asset that I procured, then I can show it as a proof that I am the sole owner for the movable or immovable asset. That would be categorized under the tangible asset. The tangible asset, I can see, I can touch, I can feel. My humble request to one of you, the same attitude you please try to keep whenever an idea conceptualized in your mind, the intangible asset, the asset that I can feel, but I cannot touch, I cannot see, intangible asset. But the real reason why I'm asking you to register that intangible asset, the same reason why we are registering movable or immovable asset in our name. We are creating the value by registering the intangible asset in our name. Even you name any company, their company asset, most importantly on the basis of an IP asset, then IP, the how many IPs they are holding. Not only for the companies, even any company, they would have started from a simple idea. Those ideas, they would have got the protection. Their protection only, of course, it has made them what they are now, what they have become now. So, irrespective of whether today we are all an individual only with an idea, but we also can become an entrepreneur, we also can become a corporate at the later part of our time. Only thing that we have to mind is how I got the protection for an idea that I have I have on today. That is so important. So once again, I would make a very humble request to one of you. Please have a same attitude. Whenever you have an idea in your mind, try to get the protection for your idea that would help you in the later part of your career. This particular slide, of course, it would give you the overall glimpse of information about the various intellectual property component and the span of life that you would get protection from the patent office. For an instance, for the patent, the lifespan of the patent, it is a 20 years time period. For the 20 years time period, the inventor, they would get the monopoly right. They can make it, they can use it, they can sell it, they can import it, all the activity they can perform for the period of the 20 years. Once the period ends, the invention goes to the public domain. Anyone can make it, use it, sell it, import it. For the design, you all would have heard about the word industrial design, the design pattern. For those design, you would get at the initial period, the 5 years, every 5 years, you have to renewal it. The design, which would encompass the aesthetic look of any product that we are making. For an example, if you want to file a patent for a water bottle, the aesthetic look of the water bottle would be created under industrial design patent. But the same bottle, whenever it has the functional aspect, for an example, if I do have one level sensor, if I do have one IoT module, so that anywhere else that I can understand who is touching my water bottle and how much the water it has been consumed. If the water bottle, if tells me those information, that particular information would fall under patent. Now you could understand the difference between the industrial design and the patent. The trademark, any company in their emblem, their logo, their words, their any descriptive items, the color, the position, it would come under trademark. For the trademark, the protection we would get for the period of 10 years. For the every 10 years, we have to make the renewal. The copyright, it is for the lifetime of the creator. After his lifetime, 60 years thereafter. Any artistic work, literary work would fall under the copyright category. You all would ask me, sir, as an individual, a faculty or the student or the startup company, why I have to protect my intellectual property? Why I have to do that, sir? What importance it would be? Why I have to do that? If you have the similar thoughts in your mind, please read the statements that it has been brought to give you the clarity on that, why I have to do that. Even though that you are an individual, you have not registered your startup, you are a student, you are a faculty, whoever the people they are hearing this particular the lecture, protection of intellectual property equally important to every one of us. Nevertheless, that you register your startup, nevertheless, that you have created an idea, nevertheless, that you have been involved with any other project work, but seeking the protection for an idea, it is equally important to every one of us. It would protect the rights of owners from the competitors. For an example, imagine you have an idea and you really thought that idea, it has the potential, the revenue potential. And what you have done means you got some loan and you are spending energy, time, and you made a end product and you are selling the end product in the market. Now the product, it is being available in the market, and you are getting some revenue out of it. Any other person who is who comes to know about your the product, they are getting your product from the market, and they understand, oh, this product looks very fine. I also wanted to re-engineer it. I also wanted to recreate the same model. He also can do that. He also can establish the manufacturing facility that you build. He also can create those kind of the model. He also can sell the similar kind of the products into the market. Even for an example, in your product, when you are fixing the cost 100 rupees, this 100 rupees involves the R&D expenditure too. Why it is so? Because you created from the scratch, then very obviously your unit price would include the R&D expenditure. But for him, he does not require any kind of an R&D expenditure, because you have given you all the ideas how the product it has to be built, it has to be manufactured. So his product cost would be very lesser than your cost. For an example, 80 rupees. You cannot bring down your price to match with your competitor price to the 80 rupees. Why it is so? Because then very obviously you would end with a loss. You have to add the R&D expenditure too. Now imagine a very different scenario. You have an idea, you got the protection, you spend all your money, energy, time, and everything in making it as the product. You are selling the product into the market. Any competitor or any person, not only from India, in any part of the world, you come to know that they copied not only the whole product, any of single modules from your product. If you come to know that the other person, any part of the world, they are copying a single module in your product, then you can enforce your patent rights. That opportunity that you would get with the protection that you are going to have by filing and appropriate the document. It would allow the review of research and development cost. Even I know, because we have been doing this job for more than 2 years. Very fortunately, by God's grace, we have been supporting number of startup companies in filing their patent. One such a company, they filed one patent, and that particular the patent required the huge investment. Then what they did, instead of investing in manufacturing the product, they identified the company, they transfer the license to the other company. And now they made the transfer license agreement in such a way that whenever the company, they are selling any product, and this company, because of these people are license holder, the patent holder, they would get revenue out of it. Now, do you know what this the startup company for whom that we supported, they are not into manufacturing of any product so far, but they are identifying the solution for the number of problems associated with the public as well as the companies, the industries. They would identify the problem, they would find the solution, they would get the patent protection, then they would make it as a prototype model, then they would approach the rightful company, and they would see the possible technology transfer to the company. They created the startup only to involve themselves on the R&D part. Now you all would understand the importance of getting the protection. Imagine if there is no patent protection, would you think that anyone would involve those kind of the innovations? Even you take our human, the history of human, from the Homo sapiens period, this 20 years, 200 years time period, we have been seeing the number of innovations. Even the last 50 years, it's a tremendous science and technology advancements that we are all witnessing. Very fortunate we are all. Even you in your generation, Even we completed our BE then at the year of the 1999, that time only that we come to know about the mobile phone and all those kind of the thing in India I'm talking about. But when you come to the world, of course, you all know that what is a mobile phone. Even at your age of one, the first birthday, even some of you would have received the birthday gift as a mobile phone. Even the next 10 years, we are all going to see more number of innovations. In our some of our shopping mall, they would have some kind of the bio organ shop there that we can go and we can shop any bio organ that we wanted to fit in, any skin or any kind of the body parts. Even the next 10 years, even Elon Musk, of course, he gave one interview in such a way that he does not want to concentrate more on the electric vehicle rather than on the robotics. Because why it is so happened, in the 10 years down the line, there is going to be the robot which would be having the bio organ. Similarly, the human body would be having the robotic parts into it. That kind of the innovation that we are all going to see in a period of 10 years or 20 years down the line. You all would wonder why the company, they have been doing this kind of the innovations. Because they all know that whatever the innovation they are bringing as an end product, they are bringing into the market, equally they would get the protection. They are the sole owner for those innovations they are going to build. And those innovations, of course, they would it would help them to get the profit. My humble request to all the students, faculty, we also should join in those, at least some of the innovation, it is going to come in a period of 10 years or 20 years. We are also have to take a part of it. For that, having understanding on intellectual property plays a very vital role. It would encourage the innovation. It would give the monopoly right in exchange for the full disclosure. It would provide the revenue stream. It can be licensed or sold. It would protect your investments. It would drive the economic growth and competitiveness. It would create and support jobs. This picture that I have taken from the internet source. If you are looking at this picture, it conveys a certain meaning. For an example, let me look at this picture. Without real estate law, land would not exist. What does it mean? If there is no existence of real estate law, would you mind to invest on land? For an example, today I am buying a home, that tomorrow anyone else can occupy my home. Then I cannot do anything. If there is no real estate law, that would happen. But what right now it is happening? Whenever I am procuring a land that I have the registration document, no one can capture my land. So because there is a existence of real estate law would protect my investment. Similarly, all your innovations, all your inventions that you are all going to involve, equally you would get the protection. So my humble request to every one of you, once again, please involve yourself in the innovations as well as the invention. IPR and startup. Some of you might be having an idea of establishing your own startup, because we all know that the RER, NARF ranking and all those kind of the thing, it gives the more and more importance to the startup. Even our student this year that they have registered 3 startups. So we are all hearing this word again and again, even from our student group as well as the college also, they are promoting the kind of the startup. This is the right time to understand how these two terms, as a startup, what the kind of the protection that I would get. But remain one point. These points, of course, not only pertinent to the startup, also for any individual. You just think in that aspect. If you have already established the startup in your hand, or if you want to establish the startup, of course, you think from that perspective. You don't have an idea, you are an individual, a faculty or the student, but these points also relevant to you too, right? It would protect before the launch of the products and ideas. Any startup, of course, it would start it from their idea, right? Any startup, not only here, anywhere else, the startup, of course, it would start from their own idea. So then idea, it has to be protected. But before launching their product, they have to ensure that they got the protection for the idea. Then this would be the most the important aspect. Most of the startup, the founder that we have been discussing with them, and they were telling that, sir, which kind of the patent, which kind of an intellectual property that I have to file. My startup, of course, relevant to some kind of the software algorithm. Whenever I wanted to file a patent, the patent office, they are telling that I cannot file a software algorithm. Then how I could get the protection? My startup, of course, it has only the business model. That business model needs to be protected. Then which particular the category of intellectual property that I should get? My company logo and everything, of course, it likes this kind of the protection that I wanted to get. Then what kind of the intellectual property that I need to get? So that then aspect, whenever you have been discussing with the knowledgeable person on the intellectual property, of course, they would give you the much more information, more specific to your the doubts or the queries. This would be so important. Even though this topic not relevant to patent searching, if I do get an opportunity that I would talk, we can have the discussion on the patent searching, the strategies and everything. But I could tell you some glimpse of information about the importance of having the patent search, especially for the startup or otherwise an individual. The patentability. Whenever I have an idea, I need to understand whether this idea, it is a new or not, whether this idea has been coined by anyone else in the world, the other part of the world too. How I could ensure that? By performing with the patentability search. Freedom to operate. There are two things are so important. I would never allow anyone to trespass into my land. Similarly, I also would not trespass into any other person the property. Most importantly, I would not misuse any other person's patent. Similarly, I also would not allow anyone to misuse my patent. How I could understand? By performing it through freedom to operate. Patent invalidity search. The protection that I am getting, of course, it would help me to get more and more revenue. But what would happen if my product, if some of the modules in my product, it has been copied, it has been misused by someone else, not only here, in some part of the world, that also would impact on my the revenue. Then how I could stop them? How I could identify whether they have copied my patent or not? By performing it through patent invalidity search. State-of-the-art search. For an example, I have had some certain kind of the technological advancement in my patent, in my product. But at the time of releasing, there might be a new addition of the technological advancement. If I do not consider those new technological advancement, when I release my patent, my invention into the market, my competitor would add those values, those new technological advancement, and they also can get the new protection. Then what would happen? You cannot add those newer modules into your product. Then you have to get the technology transfer or the permission from the other person. In order to avoid that kind of the embarrassment at the later part of your the product selling phase, what you have to do means you have to analyze the technological advancement. Very recently it is happening. Then that clarity that you would get by performing it through the state-of-the-art search. When you are performing these search again and again, very obviously as a startup, these intellectual property rights would help you to enjoy your monopoly right, as well as your profit also would be very much answer. This one, most often, most of the startup founder, they are all making this mistake. They are not maintaining the secret. They are not maintaining the secrecy before the launch. They are telling in some other than YouTube videos or some other the interview what kind of an ideas they have in their mind. But they have to ensure that before receiving the protection, they should never disclose their content in the public domain. How an individual get the profit from an idea? I told you very clearly, if you belong to a startup entrepreneur who listens this particular the discussion, you imagine, of course, that you are the startup. If you have not registered your startup, you are an individual, staff and student, then please mind that these points most importantly relevant to you also. Do not restrict yourself. Oh, this slide, it's only for startup. No, actually not. The very first foremost thing, in order to inspire the profit from an idea, to have an answer for this question, is there a market for an idea? Can you exploit the market directly or via a license? I told you in the previous example, one startup, they made a product and they got the protection for the product, which required the huge investment, and they identify another company and they made the technology transfer. The other company with whom that we have been collaborating with them, supporting for them in filing the patent, it's pertinent to, it's a kind of the software, it's a mobile application programming interface, which required no huge investment. Then we advised them, why don't they directly go into the market by creating their own startup, and they did. Now they are into the market. The point here is, if you have a protection, you would get two opportunities. Either you yourself can establish your own company, or otherwise you can identify the company for the possible technology transfer. Is it likely that your competitor arrives at the same idea? Even today that we are all going to see India versus Sri Lanka. It's the test match. One of the technological advancement that we have been seeing very recently, the cricket stump attached with an LED arrangement. Cricket stump attached with an LED arrangement. The moments the bails comes out, the LED will be illuminated. This is the invention. This invention, this product, Australian manufacturer, they got the protection. It happened 7 years before. And this patent, it has been filed in more than 85 cricket playing countries. They filed this patent in more than 85 cricket playing countries. Do you know the cost of this stamp? You cannot buy this stamp. What you have to do means for a day match, for 1 day, 7 stamps of 7 set of stamps that you can procure, and the next day that you have to return those stamps and you have to get the new set of 7 stamps. That is a agreement. And for this 1 day, 7 set stamp, if you have the Google access, you yourself verify it. They quoted around 25 lakhs. My question here, every one of you, when I do say anything about the mobile phone, that I can imagine hundreds of manufacturers. When I tell you a laptop or any electrical or electronic appliances or any particular the product, there are a number of competitors are in the market. All those products equally are substantially, of course, they got their protection. Even Apple, when they are introducing Apple 13 now, so it has hundreds of patents into it. So the product, every other product, they comes with the patent. Why this particular the stamp? Why there is no competitor in the entire world? Why this Australian manufacturer alone, they are enjoying the monopoly right. Even though we all understand that the cost for this stamp, 25 lakhs, it's a very exaggerated cost. The manufacturing cost would be very lesser price. Even after that too, the customer, they are buying from by paying this much of amount. The real reason, in one of their claims, this manufacturer, in their patent document, they mention the LED illumination will be done with a throughput of 1,000th second. The LED light will be illuminated within 1,000th second. If you and me or anyone in the entire world, if they are able to make a stamp with a better efficacy, better performance than this 1,000, then if you are able to bring 1,000 to 1 second, you and me also can file a new patent. My humble request to every one of you, whenever you are filing a patent, please ensure that you got the extended protection so that a competitor, they are not arriving with the similar or higher performance product in a period of 1 or 2 years. If you do not have a competitor for your product 1 year or 2 years, you would enjoy the monopoly right and your profit would be more and more. Please ensure that. Or licenses of other ideas, patents required to commercialize that your invention. Imagine you are standing before a wash basin. That wash basin, it has the hydraulic height adjustable wash basin. That invention that you made, whenever you go nearer to the wash basin, it has to match with your height. It has to understand what is your height, and accordingly, the height it has to be adjusted. A kid, a 2 feet kid, when she or he goes nearer to the wash basin, the height it should be scaled down. This is the invention that you got the protection. Of course, for this invention that you would get the patent. But before you release this height adjustable wash basin into the market, you have to ensure that you have to, or you got the license from the wash basin patent holder, because you got the patent protection only for height adjustable wash basin. Then you cannot sell that alone into the market. You have to attach the height adjustable, the hydraulic arrangement with an existing wash basin. Then only you can sell that as a finished product. But this assembly requires the wash basin. You don't have the patent, the protection for the wash basin. The wash basin might be having the other person, the patent protection. So before you release this product into the market, you have to ensure that you got the license from the wash basin. If it is not, what would happen? After you release this product into the market, the original patent holder for the wash basin, they would start to enforce their patent protection. They would file the litigation case against you. So please careful. I told you earlier too, the freedom to operate search. There are two aspects. One is that I am not trespassing into others' property. Similarly, I would never allow trespassing into my property. Is it easy to reverse engineer? This particular advice that we would give to all our startup founder. When they do have the chip, for an example, Arduino, the Raspberry Pi, if they are using the readily available trademark items, when they have incorporated within their product, whenever the buyer, whenever they are seeing the chip number, they could understand, oh, this chip this fellow has used. Then what would happen? And he could easily identify where and all the input ports are available, where and all the communication ports are available, where and all the power and everything. Because this particular the chip is known chip, and everyone would understand what kind of the interfacing it has been done. Then easily they can reverse engineer it. So in order to protect your the product, we advise the startup founder, why don't they make use of some application specific integrated circuits, ASIC, so that that particular the ASIC, it's a generic chip, does not have any kind of the chip number, so anyone cannot understand the kind of the interfacing kind of the thing, the ports number and everything, it has been incorporated within. So please have a thought about it. Is it easy to design around it? For an example, you got the patent protection for one data acquisition board. Data acquisition board, normally it would be having sensors, signal conditioning, microcontroller, and then actuator. This is the data acquisition board. You have illustrated this data acquisition board with all the wired interfaces. You have the serial communication, you have the parallel communication, you have the RJ45, you have the USB, you have all the wired communication that you have described in your invention. But you have not mentioned anything about wireless interfaces. You have not mentioned anything about the Zigbee. You have not mentioned anything about the Wi-Fi, Bluetooth, or RF, or LoRaWAN. You have not mentioned anything about it. Then what would happen? Your competitor, they would identify what kind of the platform that you have implemented, and he would replace the wired interfaces with the wireless. You cannot do anything. You cannot file a litigation case against him. Why it is so? Because in your patent document, you never mentioned anything about the wireless interfaces. So my humble the suggestion, every one of you, whenever you are filing a patent, whenever you are making a product, ensure that the other competitor, they cannot build a design around it. Will it be easy to identify the violation of patent rights? How I could identify the violation or the misusing of any of my modules for which that I got the patent protection, not only here in India, anywhere else? What kind of the strategy that I would follow as a startup or as an individual or anyone else? Are you ready to invest time and financial resources for enforcing the patent? If you come to know that one person, they are misusing your patent protection, then what would you do? What kind of the litigation procedure that you would take? All these things equally important in order to ensure the profit from our idea. How I could create an impact? I can have an updated NDA document, non-disclosure agreement, even at the time of hiring policies. If I am a startup founder, if I do hire a person, then I would have some kind of the NDA policy, so that my employee would not share the kind of the product he has been involved with the development. Even if I do outsource any of my module, then if I do have the properly built an NDA, then I could understand that I could ensure that that person, he is not disclosing the content to anyone. The IPR ownership and the sharing mechanism within ourselves, because a startup, when they are building, of course, they have to have the technology, the license, then agreement with the number of person. Very obviously, the startup, they cannot hold, they cannot start with their own employee. Instead of that, each and every kind of the thing, they would add the partners. Even I have created the two startups without I start with my own employees. What I am doing means I'm just building the team. Whenever I am expanding my team, then I would understand, oh, this particular the product that you and me, we are the co-owner. And for this particular the product, my revenue, it is going to be 85%, and yours is 15%. In the third one, so you are going to enjoy the maximum sharing, 60-40. So all those kind of the thing is so important, and that would be designed, that would be clarified on the basis of the contribution. So outsourcing, I was mentioning about the continual assessment on core aspects and type of IP protection that I got. So the company name, it should be so unique, so that no other person, they would replace some of the words in my the company name, and they also would develop establish another one startup. The patent invalidity mechanism, the global level, it is so important. Involve and educate people out company own IPR using trademarked item and open source. We should be so careful on that. IP litigation policies and existence. So this particular the topic requires a more and more time. I really do not know how many of these participants have been established the startup. What we could do means we can arrange a special dedicated session for those people, the people who have established the startup. Then we can discuss these items in a more detailed manner. Some of the common mistakes the inventor they are making as per European Patent Office. This particular the picture and the next picture that I have taken from European Patent Office. You see, we are seeing the two characters here. Those people, they have the same the problem solution. It's a nut cracking machine. And this fellow, he is holding a nut cracking machine. It's a handheld kind of the model, which would deliver the same aspect. But this fellow, this character, he is having some kind of the complicated structure. As an inventor, every one of us, we have to think either as how this person has made the system, or this person. As a customer, which model that we would prefer to buy? Obviously, this model, right? This simple model, not this complicated one. So we also should think in the same manner. Whenever we are building any model, whenever we are bringing out any solution for the problem existing, then that solution, it should be so simple and straightforward. This fellow, he wanted to have the thrust force can be executed from two pulley arrangement to open two bottles simultaneously, but very obviously, no, that kind of the force cannot be possible. So it could not be possible even for him to open a single bottle. This fellow, he is holding a wheel. So from the historic period, this invention, the people, the mankind, which known to everyone, so no one would prefer to appreciate him. And this fellow, he is not maintaining the secret. He is disclosing the content to everyone. So in the startup or in invention, in the patent or intellectual property, disclosure finds or plays a very major role. This fellow, he has made some kind of an apparatus, but no one would prefer to buy it. And this fellow, he does not know the real value for his the invention. So he would not be contacted by anyone. So these are all some of the common mistakes we inventors, of course, to some are extended manner that we have been doing. Please, we try to avoid that. What is a patent? The patent is an exclusive right which would give the inventor, the applicant, to make it, to use it, to sell it, to transfer it, or to import it. It is a territorial nature. When you have a patent protection in India, you can do the business only in India. When you have a patent protection in USA, for an instance, you cannot do the business in India. When you have a patent in India and you come to know that someone in China, they are abusing your patent, unless otherwise that you are filing a patent there, you cannot file a litigation case against the person. Now you could understand the patent is territorial nature, the protection that you would get only within the territory. Even the kind of an enforcement, if you want to make, that enforcement would be possible when you have registered the patent in the particular the state. It is a 20 years time period. Once the period ends, it goes to the public domain. So anyone can make it, use it, sell it, import it, or transfer it. The patent is for any field of technology. It could be for mechanical, it could be for electrical, it could be for electronics, it could be for computer science, it could be for pharmaceutical, it could be for chemical, biochemical, for the pharmacology related thing. Any field of technology, it has its own deservedness to go for the patent protection. It is a simple contract. you all understand that for an instance, the KFC and the Coca-Cola, they have never disclosed their recipe information for the period of 60 years. That would fall under trade secret. That would fall under trade secret. But if it is a patent, as an inventor, that you are ready to disclose the content with the public through the patent office, the patent office, they are giving you the protection in the form of certificate. It is a simple contract. What can be patented? In the earlier slide that we were talking about, the patent is for any field of technology. Under those technology, any process, any method, any product, any device, any instrument, any system, composition of matter, it can be filed for the patent protection. Those items, either it could be either new or improvement of the existing. Now you could understand, right? So you can build a new thing, or what you could do means you can improvise an existing product, what it is available in the market. So for that also that you would get the patent protection. Why it is so important? I would instruct very strongly with all my clients, the patent should be considered as a revenue source model rather than the certificate. Even the patent office also would never allow you to hold only the certificate. They would ask you periodically what kind of the commercialized an activity that you are doing with the obtained the patent grant certificate. So it is so important. The patent, it is not a certificate, but it should be considered as a revenue source model. It would be considered as a bargaining chip. For an example, in my earlier example that I told you that some student, they got some patent protection and they transfer the technology to the company. Do you know, or would you ever think that, imagine those students, they do not have the patent protection and they are disclosing the content with the company. Would the company would come forward for the technology transfer? Or otherwise, those the student, they published in a journal, reputed journal. You imagine Science or Nature or some other the reputed journal, they made the publication. Now the contents are there in the public domain. And after that, the boys, they approached the company for the technology transfer. Would you think that the company would come forward for the technology transfer? No. Even though the boys were the one who has given an idea, but now the idea, it is available in the public domain. So the company, the moment they come to know that these boys, they have not obtained the patent protection, but the idea, it is available in the public domain, they would copy it and they would not come forward for any technology transfer with them. But what these boys, they have done? The moment they got an idea, they got the patent protection, after that only they approached the company. Now the company, they understand these boys, they got the patent protection, and even though these boys, they nowhere in the hierarchical, it's a kind of in the chain, but because of the patent protection, helped them to make the technology transfer with the company. So that would be the very the important thing. With the patent protection, of course, you would negotiate with any corporate company. It would be considered as an industry control or encourage the R&D, and it would be considered as a defensive usage. Any one person, they are claiming that they got the patent protection, and you can say that you got the patent protection before them. What the patent office would look at from our document? Would they look at, oh, this person belongs to this corporate company, or this person an affiliation with that company, or the director or the founder, or this person politically he has had some kind of an influence? Would you think that the patent office would look at all those kind of the credentials? Of course not. If our patent document, for an example, 10 pages, 15 pages, 20 pages, 30 pages, or more than that, all those pages, the patent office, would try to look at only 3 elements. The 3 criteria to be followed in ascertaining the patentability aspect. The first one, new or novelty, inventiveness, industrial application. Let me tell you once again, there are 3 criteria the patent office would validate or would try to understand or would try to evaluate our patent, the patent document that we have made by ascertaining 3 criteria: novelty, inventiveness, industrial application. Novelty would be seen from the perspective of the document's availability with the public domain. For an example, imagine that I am standing before you, that I am showing a pen, then I am asking you what this object is. Everyone that you would easily recall, the moment that you are seeing a pen, then you would tell, sir, this is a pen. How you are telling that as a pen? Because the pen, the object, the particular the template, the particular the pattern, the features, it has been added, it has been stored in your brain in such a way that is a pen. What actually it is happening, this particular an object that I am showing you, it has been compared with the existing template are there with your brain. When your brain matches perfectly, then it would tell, you just go and tell him this is a pen. So there is a comparison. There is a comparison of the stored pattern there in your brain and the real-time image that you are capturing now. The patent office also would do the same thing. Whenever you are submitting a document, that document would be compared with the existing documents. Even from the period of 1911, the patent office would try to look at all those existing documents and they would identify the similarity between the documents that you have submitted, between the documents are available with the public domain. That would be referred as a prior art. The prior arts, it would be an evidence. It would be in the form of video file. It would be in the form of audio file, or it could be a journal article, or it could be a patent database, or it could be any kind of the knowledge that would be considered as an evidence. That would be considered as a prior art. When our document, when our information, when it is available in the public domain, in any of those prior arts, the patent office would tell the patent application that you have made does not have a novelty. Some of you would have seen the first examination report from the patent office. The patent office, they would have made some kind of the tabular column, and in the first column, they would mention about the novelty, 1 to 7 claims. No. Inventiveness, 1 to 7, 1 to 6 claims. Yes. The novelty, of course, it would be seen from the perspective of the documents availability with the public domain. Even when you do not have that kind of then understanding, please consider this as an example. Imagine that I am an inventor, that I made one optical sensor system. In my optical sensor system, I have a light source, I have a detector, I have a battery. Now I am submitting an application before you for your consideration for a patent. Now you are comparing with the existing prior art, then you come to know that all other optical sensor system, it is having light source, detector, and a battery. Then you would immediately tell, sir, do you know the optical sensor system that you submitted, of course, finds in all other optical sensor system, it is unavailable in the public domain. So your document does not have any novelty. Then what I did, I take it so personally, I'm so adamant. Then I had the discussion with my student. Then I come up with a plan. Okay, if I do tell one battery, you are telling that it is an existing. The kind of the invention that I have made, the plurality of energy source circuitry component. I have a one photovoltaic cell solar panel. I have a one wind turbine. I have one battery, I have one AC powered circuitry element in addition to the LED and photodiode. So now I am submitting a document, my optoelectronic sensing system with an LED, photodiode, and plurality of energy source circuitry component. Now I am requesting you to compare with an existing document. Fortunately, your search has not yielded a single prior art. The first prior art that you verified, it does have the LED photodiode. The second document, it contains the information about plurality of energy source circuitry component. Now the patent office, if they have considered a single prior art, the patent office would clarify me, yes, your patent, your application, it has the novelty. Hope you could understand. The second criteria to be followed by the patent office, inventiveness. Inventiveness would be seen from the perspective of the person known in the art. The person known in the art, the person who has the very minimum knowledge about the subject in which that I filed the patent, that person would be considered as a person known in the art. He does not need to have any BE degree, ME degree, or PhD, right? The person who has the basic knowledge about the invention in which that I made an application, then that person would be considered as a person known in the art. Imagine, again, I am the person, I am searching for one chair attached with an umbrella. I am searching for chair attached with an umbrella in the Amazon or the entire the market space, as well as the Google search and in all those kind of the thing. To my wonder, I was not able to get a single product which has a chair attached to an umbrella. Then what I thought, the novelty, it says that it would be seen from the perspective of the documents availability with the public domain. Then I got an idea that I wanted to file a patent. Okay, so to the first element, the first criteria, the chair with attached with an umbrella, for an example, it does not have any prior art, so the patent office, it has the novelty. But the second element, inventiveness would be seen from the perspective of the person known in the art. Now, who would be the person known in the art? Whoever the person, they know any knowledge about the chair or umbrella, they all know that how these two objects can be interfaced together. Either that I can use a simple thread, I can use some kind of the welding mechanism so that I can bring these two objects together. So the patent office would clarify to me, even though this document does have the novelty, but it does not have any inventiveness. Then another example that I can tell you, a pen attached with an eraser. So I am an inventor who has seen a pencil attached with an eraser, that I did replace the pencil with a pen. Now I made a new application, pen attached with an eraser. Now the patent office would clarify, even though the pen attached with an eraser does not have not been found in the literature review, but anyone have seen pencil attached with an eraser, they also can build pen attached with an eraser. So it does not have any inventiveness. The third criteria, industrial application. I need to clarify the patent office in my patent document how my invention either be used by an industry or be manufactured by an industry. Either my invention has to be used by an industry or it has to be manufactured by an industry. I have to enumerate the plan how the industrial application that it would be possible with the invention that I am making. Hope you could understand. There are three criteria on the basis of our document. It would be validated to ascertain the patentability aspect. The criteria are novelty, inventiveness, industrial application. Some other the invention that we have been doing would never be considered as a patentable invention. The patent, Indian Patents Act 1970, section 3 and 4, the full section 3 and 4, it has clarified there are certain inventions would never be considered as a patentable invention at all. any invention, any product, any project, it is against the natural law. We all know that the law of energy, one energy, it can be transferred to another energy, but it cannot be cannot built on its own. If the inventor, even in India, one person, he has filed this perpetual motion machine. The moment that you are looking at these two inventions, you all would presume that it does not require any input energy, but it works for some span of time. Actually speaking, it is against the natural law. Even some inventor, they would claim that their instrument, their device can produce more than 100% of performance. That also it is against the natural law. And those kind of the invention, those kind of the product which against the natural law would never be considered as a patentable invention. Any inventions related to the gambling or the gun related, it's a kind of contrary to public order morality, which would be considered as a non-patentable invention. Anyone who wanted to prove the existing scientific principle, scientific law, that particular the product would never be considered as a patentable invention. Any inventor, they have seen a new set of characteristics from the known substance. For an example, we all know that the medicinal value of turmeric. The chemist, he found a new characteristic from the existing turmeric powder, and he wanted to have a patent for that. It is not possible. Why it is so? Because the turmeric powder is a known substance. Even though he identify a new set of characteristics from the existing known substance, it is not patentable. But that inventor, he was so adamant, and what he wanted to do means he wanted to obtain the patent. Then what he has done, he has taken a little the composition of the neem and the turmeric, and he mixed it together, and he got some product, and he proved that the efficacy of the resultant product, of course, it is more. But even in that case too, the substances are known, right? The neem and turmeric are known substances, right? So when the mixture of known substances, it is not patentable. Section 3F clarified that mere arrangement and rearrangement of known substance. Even in the inventiveness criteria, I was telling you about the chair attached with an umbrella. Chair attached with an umbrella, it is a arrangement and rearrangement of the components. Pencil, pen attached with an eraser. Arrangement and rearrangement of the components, it is not patentable. Agricultural instruments are patentable, but the way the agriculture or horticulture it is being performed, it is not patentable. Biomedical instruments are patentable, but the surgical procedure, medicinal procedure, it is not patentable. Plant and animal part or whole, it is not patentable. Mathematical model, business method, computer program, or the algorithms, it can be considered under copyright category of intellectual property, but it would never be considered as a patent. Literary work, dramatic work, musical and artistic work, it can be considered under copyright of intellectual property, but it would never be considered as a patentable invention. Performing mental act. You all know that how unique the Bumrah while in his bowling action. When he wants to file a patent for his unique bowling action, it is not patentable. Why it is so? As per section number 3M, performing mental act, it is not patentable. The presentation of materials can be filed under copyright of intellectual property, but the way the presentation it is happening, it is not patentable. In India, topography of integrated circuits, it is not patentable. But when these integrated circuits, when it has been assembled in a device, that device, it can be patentable. You all know that recently IIT Madras, they have invented Sakti processor, right? The Sakti processor alone, it is not patentable in India, but when the Sakti processor, it has been assembled in a device or an instrument or a system, that system, they can obtain the patent. Traditional knowledge. In 1996-97, one US-based company, they filed a patent for our neem and turmeric, right? After that, they issued the notice to all our Indian medicine manufacturer. We should never use the neem and turmeric in the medicines. Only after obtaining the license, then only that it could be possible. Then what we did, our Indian government, what we did, we showed all our the evidence, even the palm scripts and everything, by proving from the historic period, all Indians, we know the medicinal property of neem and turmeric, and it has been used as a household product, and we got the rights back. Even 3 months before, there was a very long dispute. It happened between the Gujarat, the potato farmer, and the Pepsi and Co. The Pepsi and Co, they got the patent protection for one of the potato variety, and they issued the notice to all our the Gujarat farmer. Then what happened? The Gujarat farmer, they proved that from their known the knowledge, they know that the cultivation of the particular the potato variety, and they proved it. And those the Gujarat farmer, they got their rights back to cultivate the particular the potato variety from the Pepsi and Co. That all would be possible because of this kind of the law existing. Section number 3P, it tells about any inventions pertinent to the traditional knowledge, it is not patentable. Similarly, the section number 4, any atomic energy related material, the patent, the invention would never be considered as a patentable invention. It would move to the secrecy direction. Section number 335 of Indian Patents Act 1970. So you would not get the patent protection for those inventions, which involves atomic materials. So very obviously, as an inventor or as a startup entrepreneur or an individual or the faculty, this would happen. Even you all would make some kind of the project proposal or something. Even in my case, that I have been doing 10 funded projects, and now that 3 the projects are being ongoing in status. Those the 3 projects that I got the funding from the funding agency by showing the patent records. That would be possible. So the very important point is, whenever you are making any presentation with the proposal that you have made, you please ensure that you got the patent protection, because very obviously the idea is so important, not the implementation. Anyone can implement an idea, but which one is so important? An idea. In order to protect your idea, then you have to get the the relevant protection for that. As per section number 75 of Indian Patents Act 1970, the employees of Indian Patent Office, they cannot own any patent, or they cannot obtain any patent in their name. So very obviously, you can believe the patent office, its employees, they would not copy your the invention in which that you are making a patent. Some people, they have this kind of that is why that I have made this as a question. Even there are separate the discussion that we can have on IPR myth and realities. There are the myth, the people they used to have pertinent to this an IPR. So before filing, ensure that you have not made any publication, no sale of product, it has been done, no lecture or presentation, it should never be done pertinent to an idea in which that you wanted to seek the patent protection. When you have to file, the moment that you get an idea, and today itself, there is a possibility of filing a provisional specification. The provisional specification does require only the title, field of invention, background of invention, summary of invention, then abstract. You no need to require any kind of the result or any kind of the methodology that you have adapted, any kind of an illustration, no need to have. Only 2 pages which involves these components, then you can get the patent protection for that. So you have the provisions. Then very obviously, the moment that you get an idea, so try to get the protection for your concept. That is so important. The prototype, it's not required. Some people, they have this kind of the myth in their mind. So the patent office would expect to demonstrate the prototype. In most of my experience, as well as my mentor's experience, more than 96% of cases, the patent office would never requested the inventor, the applicant to demonstrate. The remaining 4% also when there is an opposition. When there is an opposition, that time only the patent office may require the demonstration of the prototype model, but not in all other the cases. So we have the patent office in Chennai. If we are the people from these states, Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and the Pondicherry and Lakshmadweep, obviously we can approach the patent office in person. We could file our patent, or by visiting ipindia.nic.in, by creating the user login credentials, we can file our patent. We have similarly, we have patent office in Mumbai, we have patent office in New Delhi, we have the head office in Kolkata. Filing a patent application for a natural person, for the startup, for the educational institution, even October 15, 2021, there were the recent amendment, the filing charges, it has been reduced to 1,600 rupees. Earlier, educational institution needs to be pay the 8,000 rupees. Now this amount, it has been reduced to 1,600 rupees. The publication of application for the natural person, startup company, educational institution, 2,500 rupees. And for the examination, natural person, startup company, educational institution, 4,000 rupees. Even very recently, AICT has introduced one Kabila scheme through which educational institution, they can get the reimbursement of this 4,000 rupees and 1,600 rupees when they are filing their patent in the institution name. So the total amount of 5,600 rupees will be reimbursed to the institution by the AICT through this Kabila scheme. They would reimburse maximum of 10 patent application the charges. The patent filing procedure, I told you, the moment that you get an idea, you can approach the patent office by filing it through provisional specification. Imagine that you are filing a provisional specification. In a period of 12 months, you have to file the complete specification. If it is not, earlier filed provisional specification will be considered as abandoned. Or on day one itself, that you have all the results, all the methodology, all other the documents in your hand readily available, then you can go for the complete specification. After filing the complete specification, in a period of 18 months, your documents will be appeared in the patent journal. Or I do not want to wait for the 18 months time period. There is an option called filing form number 9, request for the early publication with a prescribed fee of 2,500 rupees. Your document will be appeared in the patent journal in a period of, in my case, 4 days, or not to the maximum of 30 days. Your documents will be appeared in the patent journal. In a period of 48 months from the initial filing, you have to submit form number 18, request for an examination with a prescribed fee of 4,000 rupees. Then your document would be examined. They would issue the first examination report. In a period of 6 months, we have to submit the response to the patent office, to the first examination report. In a period of 3 months, our document, our response, it would be considered. They would issue the grant certificate or the rejection. So this is the patent filing procedure are being followed in Indian Patent Office. Let me tell you once again, either you can approach the patent office provisional. If you have filed the provisional within a period of 12 months, you have to submit the complete, or otherwise earlier filed provisional will be considered as abandoned. You can file even at the first through the complete specification. In a period of 18 months, your document would be appeared in the patent journal. In a period of 48 months, you have to submit form number 18, request for an examination. Your document would be examined. They would issue the first examination report. In a period of 6 months after you receive the first examination report from the patent office, in a period of 6 months, you have to submit the response. That response within a period of 3 months, it will be considered by the patent office positively. Then they would issue the patent certificate or the rejection. There are a number of the things required. In some other, if I do get the some other an occasion opportunity, that I would explain you how you can prepare these forms. There are the forms, the cover letter, and the form number 1, application for grant of patent. If you are submitting either provisional or the complete, in both cases, you can file it through form number 2, statement and undertaking. As per the Indian Patent Office procedure, not only Indian citizen or any person who has filed the patent, who has residing in India, they cannot make a application in a foreign country without obtaining the Patent Office the permission. That undertaking that you are giving to the Patent Office through this form number 3. Power of attorney, when you have the patent agent or the patent attorney on behalf of you, they are making their presence before the Patent Office in the invention regard, then you have to issue with the form number 26. Declaration of inventorship, there the applicant would introduce all the inventors for the inventions. It would be possible through form number 5. There is no prescribed fee for submission of form number 5. Request for an examination, I told you, form number 18. And if you are a startup or educational institution, then you have to submit, you have to prove it through by filing form number 28. There is no fee involved in filing the form number 28, then illustration, drawings, and the fees. So these many number of the documents would be required to file your patent application. Then opportunities for the startup, we have the patent rules and the minimum patent processing charges, and you have then exhibited examination of application and the patent facilitation. That is what that we are going to talk about now. So the startup means any entity, the establishment period, it should be 7 years, and the turnover, it should be well within 25 crores in a financial year. And they have to involve themselves with any innovations, any product development. So those people would be attributed as the startup as per the definition that we do find it from Indian Patents Rule 2003, rule number 2FB. Then you are entitled to make the exhibited examination. For an example, when I am submitting as a natural person or educational institution, my examination would be done after the period of 18 months. But recently that we have been supporting with the number of startups, even to my experience, that we got the patent, the grant certificate in a period of 9 months. For the next startup that we filed, we got the patent, the certificate 13th month. So that would be possible through this exhibited examination. There is a higher price, of course, 12,500 rupees. If you are paying, then as per this rule, rule number 24C of Indian Patents Rule 2003, your document would be examined as early as possible. There is a patent facilitation. It has been done through the Patent Office. Any patent agent who has been registered as a patent facilitator, as a startup entrepreneur, you no need to pay any professional charges to them, only the government charges, the 1,600 rupees and the 4,000 rupees. Rest of the professional charges would be given by the Patent Office themselves. At the time of filing, the patent attorney, they would get part of the amount, and after the grant, he would receive the other part of the amount. So this patent facilitation, of course, it has been to support the startup. So to file the patent, if you are a startup, you no need to pay any professional charges. The Patent Office itself, they would pay the attorney fee and the agent fee. Only you have to pay the government charges, 5,600 rupees. That would be the component, the facilitating startups intellectual property protection, SIP plan. So today we got an opportunity to understand what is a patent, and we all have seen that it's an exclusive right to make, to use, to sell, to transfer, to import, and it is a territorial nature, and it has the lifespan of 20 years time period. The Patent Office, they would validate our patent document by ascertaining 3 criteria: novelty, inventiveness, and industrial application. Novelty would be seen from the perspective of the document's availability with the public domain. Inventiveness would be seen from the perspective of the person known in the art. industrial application, either my invention has to be manufactured by an industry or it has to be used by an industry. Also, we have seen why I have to promote the IPR. We also have started our discussion with the tangible and intangible asset. And at that particular time, I made a humble request. Whenever you have an idea, you have to show the similar attitude whenever you are procuring any movable or immovable asset in order to get the value creation out of your idea. Also, we have seen why I have to promote the intellectual property and how I could get the profit from my idea. That also that we have seen. Also that we have seen what and all the invention would never be considered as a patentable invention. Also, we have seen the patent filing procedures, and the most importantly, how the startup, they can maintain some kind of the management aspect, even though it is going to be very brief, but we have seen that thing too. If you have any doubts or any clarification further required, you are most welcome with your questions.
Thank you, sir.
Yes, madam. Or you
Yes,
could
sir.
request them to make the chat messages too,
Yes.
if they have any questions.
Yes, sir. Yes, sir.
Yeah.
Participants, any questions, please post it in the chat box. Sir, actually, we have applied for the patent examination, sir. How do we pass the patent bar exam, sir?
Of course, we have been doing this particular the surveys the fifth time now, madam. How to clear the patent agent examination? Even every the session that we have been doing it for 25 sessions minimum. So the patent agent, it's a great opportunity to the student as well as the faculty. It is even for the student, they can appear for one the other opportunity with the government patent examiner. The starting pay for the patent examiner, of course, the eligibility criteria, science and engineering, of course, the 1,80,000 rupees, the starting pay. So that kind of an opportunity also would be there. So, or otherwise, the patent agent, it is going to be a good opportunity for any science or engineering graduate. They can become the patent agent, and the revenue, the profit, and it's a kind of it's a for their lifetime. So they no need to join anywhere else, and they can be a the freelancer, and they can do the job. So, or otherwise they can establish some kind of an IP firm, and they can do the patent, the registering activities and everything. So the examination would be in two parts: paper one, the paper two. The paper one mostly from MCQ type. It has the three parts, and it's a 100 marks. It would happen in the morning. So one day there is going to be two examination: paper one in the morning, paper two in the afternoon. Paper one MCQ type, and it would come from the Indian Patents Act 1970, Indian Patents Rule 2003. In the afternoon, it's mostly relevant to patent drafting. They would give you the different situation-based question, and they would ask you to prepare the patent document. So they would ask you to prepare some kind of the patent title, then objectives, the field of invention, an abstract, and the claims part. So that and all they would ask you to prepare. So it would happen in the afternoon. This also it is for the 100 marks. Then earlier when I appeared, there were the Viva was 2. It is for the 50 marks, then we appeared. So you have to obtain minimum of 60 marks. That is a pass criteria. So that would be the case, madam.
Thank you, sir. Participants, any other questions? Thank you, sir, for taking time off your crucial
Madam,
work.
please share the feedback that you
Yes.
are collecting from the participants.
Yes, sir. Sure, sir.
So
sir,
thank
sure.
you so much for the given opportunity, and most importantly, thank you very much for the participants for their patience listening and their valuable time spent. And the organizer also, thank you so much for the opportunity given, madam. Thank you.
Thank you, sir. Thank you, sir. Sir, now I request Dr. Benila Tangamal ma'am, Professor, Department of ECE, to propose the out of times. Please, ma'am.
Good afternoon to all the dignitaries of this forum. It gives me immense pleasure to propose vote of thanks for this wonderful program. I extend my gratitude to our guest speaker, Dr. Balaji Ganesh, to take out time for his best vicious schedule to accept our invitation and deliver the lecture in IPR. Thanks for sharing your expertise in IPR with us, sir. I express my sincere thanks to our management and principal for arranging such an informative webinar in our campus. I thank the organizing team, Dr. Elumali sir, Professor and Head of the Department CSC, Dr. Srinivasan sir, Professor and IPR Coordinator, and Ms. Kartika EDI Coordinator for working hard to make this webinar successful. On behalf of IIC, I also wish to express my gratitude to the heads of various departments, academic coordinator, professors, faculty fraternity, and my student friends who are getting involved in this webinar. Thank you all.
Madam, I got message from Dr. Srinivasan to switch on my camera. So should I do it now, or you already captured the moment?
Sir, not it, sir. Just,
Sir,
Should I do that now?
sure, sir, please.
yes, sir. It's normal today.
Thank you, sir.
Thank you, sir.
Madam, with all your permission, that I am leaving from this room. Thank you.
Thank you, sir.
Thank you, sir.